5 minutes for questions. Director Cordray, as you are well aware, in late 2013, the Bureau entered into a consent order with Ally Financial over alleged violations of the Equal Opportunity Credit Act based upon a legal theory of disparate impact. At the time, Ally had an important yet unrelated application pending before the Federal Reserve to become a financial holding company. On February 21st of this year, Michael Carpenter, former CEO of Ally, said that the charges were, quote, trumped up that your Bureau brought against Ally. He went on to say that Ally had been, quote, unquote, strong-armed by the CFPB, and that the CFPB, quote, absolutely knew they had tremendous leverage over us, unquote. Mr. Cordray, isn't it true that you and senior staff in the Office of Fair Lending knew Ally was seeking to achieve financial holding company status prior to the settlement?
So I read the interview with Mr. Carpenter, who of course is no longer
Mr. Cordray,
employed by Ally.
it's just a simple yes or no question. Were you aware, were you not aware of the pending application prior to the consent order?
We had pursued this investigation against Ally for well over a year before Ally themselves made us aware of their situation.
It's a simple yes or no question. Were you aware, were you not aware?
As I said, we had pursued this investigation for more than a year before Ally brought that to our attention.
Okay, so you were aware. That's the answer to the question. Isn't it true that senior staff in the Office of Fair Lending were in discussions with both the Federal Reserve and the FDIC on how CFPB's determination of an ECOA violation could adversely impact their application? Is that true?
We had no decision-making authority over those other matters. We were simply attempting to conclude our investigation and get to an appropriate result.
No, but the question is, were they in discussion? Was senior staff of the Fair Lending Division of the CFPB in discussion with both the Federal Reserve and the FDIC regarding this application?
I believe there were some consultations about them wanting to know if we were completing this investigation.
You say consultation, we say discussion. Can we pull up slide number 6, please? I believe on October 7th, 2013, a decision memorandum was prepared for you. I'm not sure you saw this, but it has the operative phrase, staff is in a dialogue with both the Federal Reserve Board and the FDIC. It begs the question, what does this have to do with a potential violation of EOCA? Now, I'm also led to believe, did you receive this memo, Mr. Cordray, do you know?
I do not know.
Okay, go to the next slide, please. What is also interesting is that the last sentence of the previous menu, of the previous slide was deleted. And instead, we have somebody with the initials of PAF, perhaps Patrice Ficklin, saying, let's refrain from this discussion and instead quote from the securities filing, which seems to mean that either senior staff attempted to cover up these discussions or they tried to withhold this information from you. Did senior staff try to withhold this information from you prior to the determination?
No, I don't believe so, and I think you've got the entire matter exactly backwards, Mr. Chairman.
Okay, well, regardless of whether you saw this October 7th memorandum, you certainly saw the one on October 17th. I believe these are your initials, decision memorandum for the director. And in it says, this could have a material adverse effect on Ally's business, results of operations in financial position. And seemingly you initialed this. Are you at least familiar with this report?
Again, I think you've got this matter exactly backwards.
That's not the question, Mr. Cordray. The question is, did you initial this memorandum? And if so, it would seem to indicate that you knew ahead of time that you had advantage over Ally and you used it.
Again, I think you have this exactly backwards. I'd be glad to explain.
Okay, well, Mr. Cordray, you will have ample opportunity within this hearing, but I wanted to know whether or not you saw this memo. So I have another question. In determining the racial characteristics of borrowers in auto lending context, you don't actually have the racial characteristics that you know for a fact. Instead, the Bureau uses Bayesian improved surname geocoding. Is that correct?
We use the same approach that's used in employment discrimination.
Do you use Bayesian improved surname geocoding or not?
We do the same
Okay,
approach that's used in employment discrimination cases
Okay,
across
so
this
it's
field of
Bayesian
the law.
improved surname geocoding. Okay, we have the names and salaries of the Bureau's employees in our possession, and our committee has used a public search tool to match home addresses and match names using your own Bayesian improved surname geocoding. What we have discovered is that you pay black employees almost $16,000 less than their white counterparts, which would suggest that either one, you are presiding over a racist organization, and if you are not, Mr. Cordray, should not the same disparate impact analysis you apply to others be applied to you? And if you don't believe our analysis, I would assume you actually know the racial characteristics of your employees. I invite you to do your own analysis. But should disparate impact analysis be applied to the CFPB?
I have no idea what analysis you're referring to or how carefully it was done. Disparate impact analysis applies throughout this field of law. It was upheld by the U.S. Supreme Court last June in an important decision. And if you're going to do that analysis, you would need to correct for pay bands and different jobs. I have no idea whether you did that or not, so I would not.
Well, Mr. Cordray, I'd invite you to do your own analysis, and I must admit the evidence is fairly overwhelming. I'm not sure there was any justice taking place here, and I fear what we are seeing are shakedowns for headlines, and this has got to stop. The chair is way beyond his time, and I recognize the ranking member.